Hey guys, Jonathan LaCour here again, and we're going to go through some of the most common topics for workers' compensation. The first issue is going to be denied claims. Let's face it, it's happening more and more these days. The second is going to be whether or not you're entitled to workers' comp if you are injured either off the job site or outside of the office. The third topic is what your employer has to do if you're back at work with that workplace injury. Well, let's start with the denials. Let's face it, the insurance system has an incentive to delay your claim. So what we're seeing a lot more these days is insurance companies and workers' comp carriers denying the claim, so you have to jump through a bunch of hoops to get the treatment that you need. And let's face it, you need somebody with experience to handle that situation for you. So let's go through a denial and what you need to do to get your case back on track. So the first thing is, don't panic. A denial isn't the end of your claim. And frankly, it doesn't mean you're not going to get paid out, and it doesn't mean that you're not going to get treatment. So the first thing when you get that notice is to not panic, because that notice can be a little bit jarring. For us, what we would do in that instance is file an application for adjudication before the court system. We are going to have to show 1% industrial causation of that injury. Let's be real, that's not a lot. So long as we can show 1% industrial causation for your injury, we can get that denial overturned. And what that means is your case is going to be right back on track. You're going to be getting the treatment that you need, and we're going to set you up for the max value that you can get for your claim. Now, let's talk a little bit about what your employer has to do if you're back at work and you're injured. California employment law requires your employer to engage in a good faith interactive process to accommodate you, so long as it doesn't create an undue burden on the company. So they have to do something called an undue burden analysis to determine whether or not your requested accommodations are going to create a hardship on the company. And if it's not going to create a hardship, in California, the law is really specific. They have to accommodate you. And that's where you need somebody like us explaining what plausible accommodations could be for you and your workplace injury. When you go to your workers' compensation doctor, if you're returned back to work, you're going to get a note, a doctor's note, with restrictions most likely. Those restrictions are going to require your employer to modify your position. Do not ignore these restrictions. They are there to help prevent an additional injury and to ensure that you are in the healing process. If your employer is violating these restrictions, that can be a violation of California law. And if you're represented by us, we can connect you with one of our employment lawyers to discuss the civil side of a workers' compensation claim. And the final subject is what happens if you're injured off of the clock or outside of the office or your work site. We get this commonly. COVID sent most employees to be working remote. And believe it or not, we've gotten a large number of workers' compensation claims for those individuals that are working remote. California law doesn't really care if you're on site. California law doesn't even care if you're on the clock. What they do care is whether you got injured on the site or through the performance of your job duties. So if you are off of the clock and on site at your employer and you get injured, you're covered. If you are off of the clock or off site, but performing the duties for which you were hired, you're also covered. Common examples that we see for this are salespeople driving to a sales call. If you're in a fender bender, not only would the third party be responsible, but we'd also have a workers' compensation claim for you being injured at work. What if you're picking up supplies at Home Depot? Well, if you're injured doing that, you're performing the job duties for which you were hired. You're going to be covered for that as well. What if you're playing golf with a prospective client and somebody hits you with a golf ball in the head? That's going to be covered too, because you're within the course and scope of your job. As you can see, there are a ton of ways for you to be either off-site or off of the clock, but for you to still sustain a workplace injury that would be covered by the workers' compensation system. Give us a call and we would be more than happy to talk through your situation with you. Thanks.